Clerk, you may give your closing argument.
Thank you, Your Honor. May I have leave to set up that easel, Your Honor?
Yes, sir.
Thank you, sir. May it please the court, opposing counsel, Madam Clerks, Mr. Court Reporter, Your Honor, ladies and gentlemen of the jury. First, let me start by, if we could, both sides could stand up and give you a round of applause right now. We would do that. You all have been very attentive. You have paid attention to numerous witnesses, especially the ones that were on video. And that can be tedious at times. And on behalf of both parties, I know I can speak for us, thank you very much for paying attention and doing your service now into the second week. When I stood up in jury selection, which feels now like a month ago, but it was only like a week and a couple days ago, it was one of those days where we were talking, I was throwing a lot of subjects at you all from scratch, basically. We were talking about a bunch of different things, but one of the things I tried to really hammer during jury selection was this idea of bias. And I said, I was up front with you all, and I said, this case is about a lady in jail, and some people may not feel comfortable sitting in judgment of that because they may automatically start out favoring the people on the other side of this instead of the person that I represent who was in jail at the time. And we went through a lot of the bias discussion, and I had everybody basically tell me whether they were comfortable with that. Because some people may start off in a place where the person that was in jail has a strike or two against them. And I wanted to make sure that we didn't have anybody like that on the jury ultimately. So we went through all that. And in that discussion, we talked about, I was reading from jury instructions that you all now have in your hand. And one of the jury instructions was jury instruction number 700. In that jury instruction, among other things, it talks about bias. And it says basically, in reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision. Your verdict must be based upon the evidence that has been received and the law that I have instructed you. It goes further and says, even if you do not agree with these laws, you must use them in reaching your decision in this case. So I know we went through this in jury selection, but I want to make sure that it's reaffirmed that the law that the judge provided you in your hand in that packet and the evidence in this case, which includes the testimony that you heard from the witness stand, is all that can be used to make your decision in this verdict, in this case. And if somebody, the instructions go further than that. If somebody in the jury decides they want to go outside the law, outside the testimony, outside the evidence, the instructions basically say you have to alert the judge to that, because that would be improper. I know this is a review for you all, but it is something that we covered, and it's really important that we talk about. If you become aware of a violation of these instructions or any other instructions I have given in the case, you must tell me by giving a note to the bailiff. That's how important they are. Let's say one of the jurors is discussing evidence and they say, yeah, well, I would typically view this case if it was in a hospital or in a doctor's office like this, but you know what? She was in a jail. So the care she got because she was in a jail, we should look at differently, or we should give her less ability to complain about that because she's in jail. That would be outside the law, outside the evidence. And it would be important for the other jurors to remind that juror that we have to stay within the bounds of the law and what the law says. The other thing that I talked about in jury selection was drugs. I think I said substance abuse. And I asked everybody on the jury first, and everybody pretty much raised their hand, who on the Venare, the panel here in the room, has anybody in their close family or friends that has been affected by substance abuse? And pretty much every other person's hand went up. And the reason I was talking about that was I was trying to see if the issues of somebody having a substance problem was going to prevent a juror from being objective. For instance, a jury saying, you know what, I typically would think that if this person didn't have a drug history, that he or she would be entitled to this level of care and I would have this level of expectation, but because she has that history alone, not some medical basis, but because she has that history alone, I can't really be completely fair to the judgment of this case because I couldn't help but consider that. And we went through the fact that that would not be a good juror for this case. That also flies back to these instructions. Do you have the verdict form that we can put up? Your Honor has referenced the verdict form. So I like to structure my discussion with you all around how I think the discussion might be, if you decide to be, along this verdict form. So the verdict form starts with, we the jury return the following verdict, and it's numbered. And it's numbered, on the first page you have a question number 1 and a question number 2. And the first questions that you're asked to decide in a case are the liability questions. Liability questions in this case relate to negligence, medical negligence. Negligence is a fancy word for reasonable care. And the question you have to answer is whether or not these individuals were negligent. Nurse Amy Baldwin or nurse practitioner Byers or Armor by through its agents, the employees. Were they negligent? So then you have to think back, what evidence did the plaintiffs and the defendants give you in regards to negligence? Most of that came from the witness stand. Dr. Fournier was our expert on standard of care. Remember the fancy word standard of care? Did you breach the standard of care? That's the term that's used, or the terms that are used to illustrate negligence in a medical malpractice case. And where did you hear breaching the standard of care in this case? Let me please start with the defendant's expert, Dr. Suarez. Dr. Suarez admitted in cross-examination yesterday that if nurse practitioner Byers did not see the patient until the 14th, it would be a deviation in standard of care. You have to go no further to establish a yes to number 1 than their expert. There is more. if you choose to go further, because in addition to their expert admitting it, Dr. Fournier, who told you his credentials, gave the opinion that Nurse Baldwin and nurse practitioner Byers breached the standard of care that they independently had to Miss Williamson. And he explained in his testimony why that's the case. I know these things can be annoying, and I hope that you weren't annoyed by me. If you were, I apologize. But these Post-it note things that I do, I like them because they stick after you do them. And you can pretty much put them anywhere as long as they stay up. But I went through the SIRS criteria with Dr. Fournier, and I did that for a reason. Because Dr. Fournier was pointing out that many of the vital signs satisfy the SIRS criteria. And if you satisfy the SIRS criteria, you not only have signs of an infection, but you have signs of sepsis. I did that with him for a reason. I encourage you all to look at the medical records in regards to those numbers as you lay them against the documents we have that show, or what you might have written down, about the SIRS criteria. I went through with Dr. Fournier all the visits. We wrote down the vital signs for each one of the visits. We talked about which vital signs were serious and not, what the complaints were, December 8th, December 9th. You're going to have these records back there to look at. We talked about vital signs on different days, the 110 heart rate, of course the 64% oxygen saturation on the last day. But most importantly, Dr. Fournier talked about December the 11th. That's the day that I made the biggest deal about. I made a separate sheet on it. And the reason I did that is we have so many abnormal ratings that day, or readings that day in vital signs with shortness of breath. Not only does it satisfy the SIRS criteria, you're also going to have that ENT protocol. The ENT protocol that the defendant provides the nurses to use, and let me say this about Nurse Baldwin. She was put into this managed care situation. She was just put into a situation that really made it really difficult for her to do her job reasonably. I blame Armor. The plaintiff blames Armor for that. However, they did put her in a situation that made it really difficult to do a reasonable job. And the protocol that she had was an ENT protocol. And there were some visits, there were urgent care, some visits that were sick calls. Wasn't real clear on which protocol she should use during which time. But it was clear that if somebody on the ENT protocol, can we put that up there? On the ENT protocol, it was clear that if your temperature was over 101, you had shortness of breath. Can you blow up on the thing? You had shortness of breath. Wait. This is not it. There you go. If you had over 101, the pulse was over 100, there's the stuff on the blood pressure. Shortness of breath was a separate item. I didn't even talk about 2 or more signs of infection because I felt like that wasn't clear enough, potentially. But the clearest things that we have are the vital signs that meet those standards that should have alerted immediate referral to the physician. Dr. Fournier said, had that happened, had nurse practitioner Byers checked on this patient, he would have likely heard the pneumonia because he's trained. to listen for that kind of stuff. And he would have likely sent her out for the x-ray. Now, when it comes to nurse practitioner Byers, let's talk about him for a second. Can you put up the demonstrative exhibit that has the calendar, December 9th through December the 15th? All right, so when you're back there, really the days that matter are December the 8th through December the 15th of 2016. And I've made this exhibit just to sort of a place to, it's called a demonstrative exhibit. It's not an exhibit that goes back into evidence, but it's something that I've just created to help me understand and see the evidence as it's all laid out here in these papers. It's actually just in this medical record. In this medical record, all of this information is contained. Exhibit 1. But basically you've got this trouble breathing on December 8th, and you can see how the situation gets worse and worse and worse. And the reason these things are in red is that there was a task to the nurse practitioner on December the 11th where a nurse, a manager, was saying, this may be an infection. Something probably needs to be done on the antibiotic side of things. So a task went to the nurse practitioner there. And so why in the world would, and I get that this is a Sunday, right? So the task goes to the ARMP. He is now at the facility on Monday for 4 hours at least, according to his testimony. And despite the fact that he had a task to give somebody an antibiotic for a potential infection, and he ends up filling that prescription that day for 1 dose, he did not see Miss Williamson. He ordered the meds at 11:14. The dose was given to her that night after he had left the facility. And she says, please let me see a doctor. I don't feel well and I'm scared because of my heart rate. Okay. Maybe the argument is, give it time for the antibiotic to get on board and see if it starts working. Maybe that's the reason he didn't see it. So then let's go to the 13th. He's there for 8 hours this day. 8 hours. He's going to prescribe medication, the beta blocker. Remember the beta blocker? He has this history. At 4:42 a.m., at 7:48, he prescribes a beta blocker. Remember what beta blockers do? Dr. Fournier said it works against your immune system because it slows down the battle against the infection. Dr. Schwartz said it looks like he gave it because it was countering the albuterol, but the albuterol wasn't, as you can see here, the albuterol wasn't ordered until later. So, we have nurse practitioner Byers in the facility on the 13th for 8 hours. He orders propranolol, I can't say the word, don't hold it against me or my client, please. Propranolol. And then he hears that she's got an oxygen saturation of 93%. It's now dropping. And you're going to see in the records, this is pretty interesting. You're going to see in the records that the EMR does an automatic task when your oxygen saturation goes to 93 and 92. And it automatically tasks the providers to do something. You're going to see that in it. What did he do? He ordered albuterol. Still hasn't seen the patient. He's there for 8 hours that day. It's Tuesday the 13th. And there is an order for a chest x-ray, but the day for chest x-rays at the jail is Wednesday. The order for the chest x-ray says it's a priority number 1. It says hot. But they testified, or he testified, that that did not mean stat. In any event, it didn't happen that day. He didn't see her that day. He never listened to her that day. He just called in multiple medications. After hearing that her oxygen saturation was 93, heart rate was 130, and she was short of breath. Lethargy. There's a transfer to medical while he's there, and he still didn't see her. She's in the area where he is. And he didn't see her. You heard testimony that the infirmary has to be such a size where it can be observed by at least one nurse, and one nurse has to be able to be within hearing distance of everybody in the infirmary. They're both there at 10:30. Things do not get better. There's another urgent care visit that night, 7:22. Now we've got an oxygen saturation of 92%. Another alert is automatically generated by the software system that houses the medical records. No call to the physician. No emergent transfer to the hospital. Just keep doing the same thing they've been doing and hope things work out. Now these urgent care visits, when you see the word urgent care visit, you've got to remember the process that Ms. Williamson had to go through. She was in her cell, trying to breathe through this infection that's in her lungs, and she has to go hit a button to summon a detention deputy to her area, or to her. She then has to declare a medical emergency each time you see urgent care. She has to go through this process. They have to then call medical, tell them they're coming, tell them why they're coming, and then walk her down there. And then she has to meet and discuss her situation with whatever nurse is on duty. Every time you see that, you have to think to yourself, she is asking for help. Basically begging for help. The vitals at 11:11 on the 13th include a oxygen saturation of 93%, despite, ladies and gentlemen, the albuterol and the antibiotic. Her heart rate is now below 100, but she's got a beta blocker on board. Can you put up the x-ray from, let's start with the x-ray of Miss Williamson's lungs before she goes to Santa Rosa jail. We went through this with Dr. Fournier, I believe. This is an x-ray that's in evidence from October 8th, 2016, 23 days before she's put in the Santa Rosa County Jail. And it was read, you can see the report if you want to look at it, as a normal chest x-ray. This is what she looked like before she became a patient of Armor. Now put up the x-ray, what she looked like after becoming a patient of Armor. This is what her lungs look like when she becomes a patient of Armor. While she was developing pneumonia in all, I think there's a debate right now, 5 and 6 lobes of the lung, all 5 or 6 lobes of her lungs, Nurse Byers was basically just phoning in whatever he thought might settle down the situation at that moment. Not ever considering that perhaps it would make sense to check the patient. A nurse practitioner's decision when they're steps away from a patient to not see that patient, despite all of these red flags going off, ladies and gentlemen of the jury, is more than negligent. Much more. It's an indifference to the health and safety of another person. Basically, you know what? I don't have time to go across the room, across the infirmary, to listen to her lungs. Just give her this. And we'll see what happens. If you could go back to the calendar real quick. So we go to the 14th. We have that chest x-ray. Remember, the chest x-ray, 9:42 Eastern Standard Time. Y'all may remember me talking about this at the beginning of the case. Remember I pointed out the x-ray was done by a Tallahassee x-ray company, and then it was reported Eastern Time at 9:42, which is 8:42 here. And then the first thing nurse practitioner Byers does, can you pull that record up? He sees all 5 or 6 lungs involved, or lobes involved. What's the first thing he does? He goes to the record to change something. Central Time. He hasn't sent her out yet to the hospital. The x-ray's back. He's going to the medical records trying to change something about the dose, and the system says, no, you cannot do this. Disapproved by the core ER system. He asked to see the patient. And he admits in his testimony that he didn't even do a full exam then. He just said, I saw the x-ray, she needs to go to the hospital. Go back to the verdict form, please. All right. So I told you liability, specifically negligence, was the first question. Either Nurse Baldwin or nurse practitioner Byers, either one of them, if negligent, and their negligence was the legal cause of death to Misty Williamson, your answer is yes. So it doesn't have to be both. Either one of them, if they breach the standard of care for a reasonable and prudent nurse or a reasonable and prudent nurse practitioner, then the answer is yes. Legal cause is the other component of that question. It's negligence, and it has to be the legal cause. Now, legal cause, as Your Honor has defined it for you in the instructions, is defined in the packet that's in your hands. The law says if you do something that causes or substantially contributes to, that phrase may sound familiar because Dr. Suarez, their expert, had to admit that pneumonia and sepsis substantially contributed to Misty Williamson's death. So you don't have to hear it from Dr. Fournier. You don't have to hear it from any of the witnesses. You don't have to hear from any of the witnesses that the plaintiff put forward in its case in chief or her case in chief. You only have to listen to Dr. Suarez's admission. So I made a list, remember, of all the things that Dr. Suarez and I had common ground on. There were 19 of them. Whoops. And he was critical of the fact that I had pneumonia after sepsis, and I misspelled sepsis. I just realized that. So, pneumonia and sepsis substantially contributed to Miss Williamson's death. We had common ground. Look, it's number one for a reason. It's number one because I wanted to be able to talk to y'all about it separately and most importantly on the issue of legal cause. Because their expert admitted it. However, there may be jurors that are like, you know what, he did say that, but I'm not sure that that means that that's satisfied. So what else is there out there that could suggest that whatever nurse practitioner Byers did or didn't do, or Nurse Baldwin did or didn't do, was the actual legal cause of her death? So what we did with Dr. Fournier is I went through that Sears criteria not only to discuss Ms. Williamson's condition, but for him to illustrate how sick she was when she got to Santa Rosa Medical Center. The reason that's important, ladies and gentlemen, is that the sicker she is, you heard all the experts say this, there's a 2 to 3-fold increase the sicker you are of your mortality. I think Dr. Suarez said that yesterday too. Mortality chances are increased dramatically the sicker you are. And this Cerner's criteria is what we use to illustrate that. Dr. Suarez didn't want to admit that at first, but he had to concede because it was in his book. And when you look at those factors, you only have to have two of them. You have to think somebody has an infection. Then you have to have two of the factors, like a high pulse rate, a low oxygen saturation, or fever. Any two of those with the suspicion of an infection gets you positive for the SIRS criteria. And then it's all about how are they doing. Let's go through what Dr. Suarez admits. That's common ground. There's no way to fumble it around. He says, secondly, handwriting. The texts that we have, the textbooks, including his, were authoritative. He also said that most COPD requires pulmonary function tests, especially spirometry. Now, why is that important? Why are we talking about COPD? Well, we're talking about COPD because the defendant has argued, and will continue to, that Ms. Williamson died from either drugs that made her more susceptible to cardiac problems, or her smoking history caused her to have COPD, and that caused her to die in the hospital. But no matter what they say about that, they can say that all they want. No matter what they say about that, they can't get away from this. They may want to, but they can't. He's their expert. So just remember, when they're talking about drugs, COPD, smoking, lifestyle, sex parties, drugs, assaults, whatever they want to bring up, their expert said that pneumonia and sepsis substantially contributed to Ms. Williamson's death. That's important. Because that means their expert has agreed that the legal cause is pneumonia and sepsis. So then their expert wants to say, well, she might not have gotten pneumonia and sepsis had it not been for her drug and smoking history. Okay. That's an argument they can make. But it makes a lot more sense if the medical records that they had at the jail didn't have that information in it. And you'll remember this. Dr. Suarez had a copy of the medical records that for whatever reason did not have the history of drug use and smoking. Remember me going through that yesterday, around the front page here? Also inside, on the as of November 7th, they had the medical records from Jay Hospital that had all that information on there in their system. So if you're going to make that argument, then Nurse Byers, when he made these decisions not to see the patient, despite all these bad things that were happening to her and her vital signs, back on the 13th and the 12th and the 11th, those decisions were made knowing full well that she had these risk factors, if they want to call them that, for getting pneumonia sooner or getting a worse case. They had all this information in their file. So, question number one, was there negligence on the part of Armor Correctional through its employees that was a legal cause of death to Misty Williamson? We feel confident based on that. The burden of proof is more likely than not, or greater weight of the evidence. It's just like that, it's 51%. Yes. So then you move on to the second question. It's all Misty's fault, therefore she should have liability. Misty was in jail. Misty didn't have a choice of who was going to treat her. Armor was there to treat her. They had promised the county to do a reasonable job. And the promise they made to the county was they were going to reduce their outpatient costs by 50%. That's what Mr. Cook said. In fact, he wrote a letter that said, they promised me they were going to reduce the cost of outside care by 50%. Think about how many times you've been promised something at a discount of 50%. Somebody's paying for that. And unfortunately, Misty Williamson paid for this, in part. How do you reduce outside care? By 50%? You use a lot less outside care. They say you give better care. That's what they said yesterday. This is better care? This is preventative care? I think I heard the word preventative. This is preventative care? This care keeps people from going to the hospital? This care kills you before you get to the hospital. That's a way to cut down on cost. You're basically dead on arrival. They want to blame her. They want to say she's negligent. Lifestyle, drugs, alcohol, whatever they want to say she's doing, meth and crack, and that's all they talked about. She was in jail since October 31st. Her tox screen at the hospital was completely negative. Oh, it's the history, it made her heart weaker. That's what we said. It made her heart weaker. So, what we do? We brought you the medical records from the board-certified cardiologists, two of them, Dr. Spencer, Dr. Vido, saw her as an outpatient before she went to jail in 14. She thought she was having some kind of abnormal heartbeat. She was also drunk at the time. And .225, which is more than just drunk, right? And she thought she was having a heart problem at the time she claimed that she'd had before. So what does the board-certified cardiologist do? He examines her, like physically. He has a meeting with her like doctors do. And he listens to her heart, listens to her lungs, and comes up with a plan. Let's figure out what's going on with this lady. And the plan was a 30-day Holter monitor, that's the little strap you wear on your chest, and then we're going to do an echocardiogram. And his records are right over here, and the J Hospital records are the D.W. McMillan or J Hospital? One of the two, D.W. McMillan or J Hospital, but you'll see the cardiology consult, I think it's D.W. McMillan, the Bruton Hospital. In those records, you'll see that they did, they went ahead and did those outpatient, okay? So that means Mrs. Williamson had to leave the hospital, and she had a prescription for an echocardiogram and a prescription for the 30-day Holter monitor. She then had to go see these cardiologists as an outpatient, where they examined her each time. They went through the thing, all right, this is going to be a 30-day monitor, this is how it works. And you press the button when you think there's something going on, and it will record your heart rhythm. Well, she pressed the button 46 times, and there was nothing going on. So based on that study, the board-certified cardiologist said, okay, I don't see any rhythm problems for 30 days. You thought you had 46 things that were rhythm problems, and you had 0. But in an abundance of caution, I also want to put you through what's called a echocardiogram, ultrasound of your heart. They did that too. And both he and Dr. Spencer read these reports, and they both determined that they're normal. They didn't say weakened heart. They didn't say, oh, drug abuse. There's signs of drug abuse in the heart. There's signs of alcohol abuse in the heart. They said they were normal. She's 44 years old. She had a normal 44-year-old heart. The other thing they say is that her immune system must have been lower because of her history of drug abuse. All of her blood tests indicated that her white cell count was in the normal range. You'll see those. If you want to see those, you can look through those. There's so many blood tests in here prior to her going to the hospital, the jail, you can see what her blood counts are, red blood cells, white blood cells. Never diagnosed with an immune system compromise, ever. That's their other argument. Let me tell you the reason that they want to talk about those things. They don't make a lot of medical sense. But guess why they want to talk about those things? It gives them the opportunity to talk to you about drugs and alcohol. And why would they want to do that? They want to do that because they want you to hear those words over and over and over again, so there's some hope, an idea, that you'll connect it to something in this case, potentially. Something legitimate. Those arguments have no basis in fact in this case. They don't bear out. If there was a heart problem, it would have been borne out by the board-certified cardiologist that did a round of testing in 2014. It was normal. If there was an immune system problem, all the medical records we have on her would have suggested that prior to her admission to the jail. It's not there. So the idea that she was somehow at fault for her own pneumonia and sepsis and septic shock is a negative. A big fat no there. So percentage of fault for Misty Williamson, 0. Percentage of fault for the defendant, Armor Correctional, 100. We would suggest. And then that takes you to damages. On the negligence case, can you go to the next page, please? And these are simple questions. I told you in jury selection this was about pain and suffering. And you remember me talking in jury selection about millions of dollars, because it's a death case. We didn't want anybody on this case, as a juror, that wasn't comfortable talking about millions of dollars because it's a death case involving 3 of Misty's sons and her husband. So once you get finished with the first page, you move to the second page, which is the damages for the negligent conduct, the unreasonable care that causes the death of Misty Williamson. And you have to come up with the pain and suffering for Mr. Williamson, Luke, Logan, and Alex. How do you value somebody's life? How do you value a mom to 3 sons, a wife to a husband? What is the value of that? Their combined life expectancy, or her life expectancy with her kids, and the way you do that is, I think the judge has read this instruction, it would be her life expectancy because it's presumed that the mom is going to live a shorter life than her kids. So her life expectancy, you'll see from the tables, is 38 years, 38.76 years. That's how much longer she would have had with her boys. 38 years. Imagine what they would give for 38 seconds with her, just to say bye. Just long enough, 38 seconds to say bye to their mom. I love you, Mom. Years on this earth without their mom. So that's $136 a day. I figured that would be $50,000 a year. $250,000 a year is about $750 a day. What is that worth? A day. $750 a day? At $50,000 a year for 38 years, it's about $2 million. And at $100,000, it's about $4 million. I realize it's a difficult thing for jurors to do because it's hard to do that, putting a value on the mother's life and their relationship with her boys. But the law requires that of you. And it requires you return not just a verdict, but a full verdict, full justice. There's no going back. Today's the day. For them to get full justice, for him to get full justice. The life expectancy for Mr. Williamson and his wife would have been 23 years. What is that worth? It's the same analysis, ladies and gentlemen of the jury. $136 a day, it's $50,000 a year. Is it more or less than that? That's for you to decide. Mr. Williamson told you he called to find out and understood she was getting out of jail the next day on the 15th and was trying to figure out where to pick her up and what to do and how to get her and what time. And he was told, well, she's not here. What do you mean she's not there? I hadn't heard from her in a couple of days. What do you mean? Where is she? Oh, she's at the hospital. So what's he do? He takes his truck back to his house and he comes straight back down to the hospital. And the scene that he gets to is this. Detention deputy standing outside of a door of a hospital room. I see you. And then he walks in and he sees his wife on a breathing machine. And within a couple of hours, she's dying. She coded not once, not twice, but 3 times that night. The first code was 7 o'clock on the 14th. Can we put that calendar back up? The 14th. Code blue, 728. The same day they sent her to the hospital. And they want to say, oh, well, she was stable when she got there. Let's talk about that for a second. Their position is, the expert yesterday said that Miss Williamson was stable because she must have been able to give a history. Then he had to admit, however, that she arrived there, she was in respiratory failure, heart failure, and kidney failure. That is not stable, ladies and gentlemen. Respiratory failure, heart failure, and kidney failure does not mean you are in stable condition. That means you are in critical condition, and that's what the hospital said in her paperwork. The case doesn't stop there. After you consider, can you go back to the verdict form? After you consider the damages portion of this case, which I've given you some ranges. For the boys, some ranges for Mr. Williamson. These numbers have to represent full civil justice, full value for their loss. their mom, their wife. Once that's done, you're not finished with this case. Because this case also involves what's called punitive damages. What could you possibly have in evidence that would make you want to punish Armor? I'm going to go through that with you briefly. You're going to have in evidence these things called M&M reports, morbidity and mortality reports. What number are they, Casey? Do you remember? I have 15, is that right? 15, Exhibit 15. This is all you need. Let me just give you some quotes from these. Now, this is what happens when this company has other deaths that they feel like they need to look at, that happen on their watch. They describe what happens, and they talk about how the person died in their custody as a patient. And this stack only has 2012 through 2016. Okay? Here's what you're going to hear. Shortness of breath, pneumonia symptoms treated, patient not transferred soon enough. Shock, not transferred, delayed transfer, patient dies. Armor pledges to do better. Patient with signs of infection died because not sent out to hospital soon enough. Referral to the healthcare practitioner delayed, patient dies. Three abnormal blood pressures, failed to notify healthcare practitioner, patient dies. Stat x-ray, not received for 4 days on a fracture. Pneumonia delayed healthcare practitioner transfer, patient died, Armor pledges to do better. Patient has vital signs of tachycardia, kept going back to the infirmary, chest pain, shortness of breath following 4 visits with HCP, transferred out, late transfer, patient dies, Armor pledges to do better. Patient goes to nurses with chest pain, EKG, shows acute myocardial infarction, the HCP is notified, patient dies of a heart attack, Armor pledges to do better. Fails to timely transfer, patient dies, Armor pledges to do better. Delay in transfer, Armor pledges to do better, patient dies. Sepsis, failure to transfer timely, patient dies. This is not an isolated event. Exhibit 15. When you get to the part of the verdict form that deals with punitive damages, let's go there. Under the circumstances of this case, state whether you feel that a clear convincing evidence of punitive damages warranted, yes or no. Yes. If you answered yes, the total amount of punitive damages by the greater weight of the evidence. It has to be an amount that punishes these people. They're not here admitting they did something wrong. They're far from that. In fact, they are here calling Misty and her family, basically, druggies. It is going to take a big number to get their attention to punish these people. It's going to have to be a number that gets their attention. What is that number? Maybe that number is a number that, I don't know. I think there was testimony today that a dividend was paid of $15 million. Maybe you as a jury should make that dividend come back. They need punishment. They deserve punishment. The jury instructions say that you have to, in order to find punitive damages, you have to find that one of the people that was acting on Armor's behalf was grossly negligent, which is more than just negligent. It was indifferent, basically, to the health and safety of somebody. I told you earlier that Nurse Byers, by not seeing the patient who was within the infirmary after doing and knowing all this about her case, was indifferent to her. He was grossly negligent. And then all you have to find is that the company condoned it. They had a good idea that stuff was going on, and they didn't do anything about it. Where's the good idea that they knew the stuff was going on? It's in these pages. Exhibit 15. Armor didn't know who the medical director was at the time this happened. Dr. Rummel said it wasn't him. He thought it was Dr. Nunez. Dr. Nunez says it wasn't him. He thought it was somebody else. Dr. Giannis today says it was Dr. May. De facto, Dr. May. There wasn't a medical director when this happened. Dr. Rummel said you have to have a medical director if you're running a facility. There has to be somebody. Who was it? The letter from 2013 that Mr. Cook talked about, that was written as a sales thing for Armor, that letter's in evidence. It says, these people have saved us 50% on outside care. You heard this utilization method of managed care where the utilization committee is there. Utilization is code for we're not going to let any money go out of this place until we look at it 5 or 6 different times. That's what it means. Utilization, managed care. The target of utilization was off-site care. You're going to see in the MAC minutes, what number is that, Casey? I'm sorry?
59.
59? Yeah, there it is. Yep. I'll try to put it back. You're going to see in the MAC minutes, Exhibit 59, the meetings that Dr. Giannis testified to that they have, where everybody comes and they get together monthly to talk about, he said, everything that happened in the last 30 days. By the way, you're not going to see any mention of this case in this minutes. Or, frankly, any other case, anything. They don't talk, there's no real health care discussed at these meetings. You know what is discussed? off-site care and how much it's costing. And you know who's at this meeting a couple times when he should have been at there like 12 times is Nurse Practitioner Byers and the Director of Nursing. I'm just making sure that these people know what's going on. How much money's going out for outside care? There is a dollar figure that's communicated in these about that. What else did you hear about that? Dr. May told you that they have a retrospective review, a concurrent review. There's daily reports that Mr. Berg told you about, that they email each other about, offsite cost. They have a huddle about it. Imagine if they paid that much attention to care. If they paid that much attention to care, then maybe they could be that model of preventive care that they claim they are. The documents show they're more concerned about money than they are about care. Nurse Practitioner Byers also says that the chest x-ray, when he saw it, it would have, that disease process would have been present in her lungs long enough to where somebody should have heard it. You would hear that in her lungs. But he was relying on the nurse's exam of her lungs. Is that indifference? Ladies and gentlemen, when she left the jail, she had a blood oxygen saturation of 64%. The testimony from Dr. Fournier is that is incompatible with life. And at 4:42, nurse that was taking care of her that morning said her lungs were clear bilaterally. Now it's also the same nurse that said that she wasn't sure how many quadrants were in the lungs for the stethoscope purposes, but she said they were clear. Heard that these standards that the jails have to abide by are both state and federal guidelines. One of them was the infirmary care standard that we talked about, and one of them was the nursing protocol. Those are going to be in evidence for you to look at. I encourage you to look at the infirmary care pretty detailed. It covers the situations where any patient is admitted to the infirmary, whether they're there for a hold or they're there for treatment. It covers those situations. And had the protocol been followed, It would have forced Nurse Byers, who's reluctant to come see this patient, and generate a form. But the fact that Armor wasn't enforcing those policies allowed for, condoned, ratified, allowed for this type of gross negligence to take place in these facilities. Not just here. You'll see in those reports all over the state. Anywhere they are. You're going to have in evidence the pictures, Misty and her boys, the one that was created by her boys last year, some pictures of them at younger years, of course, as they grow up, pictures of Mr. Williamson and Miss Williamson as their wedding day. This is their wedding day. You're going to have these pictures, but I think even more important than these pictures is the letters that Misty wrote. She wrote letters. She wrote letters to her boys, close in time to when she died. That's going to be in evidence. And she wrote a letter to Mr. Williamson on December the 10th, 2016. I published this to the jury because when you look back at my calendar, can you go back to the calendar? December 10th sticks out like a sore thumb in a way, doesn't it? It's blank. You gotta wonder what was going on December the 10th. Was she better? Was she worse? Did her symptoms go away? We don't know from Armor's records, but we have something in this document that suggests that her heart rate is still really high. Because she says it in her own words, right here. What's interesting, it's almost like she might have known something. She didn't, of course, but she talks about God and heaven in this letter, right after that. It almost reads as if she knew this was the last thing she was really going to say to him.
Objection. Please approach. Ladies and gentlemen, the letter referred to is in evidence, and you can read it. Plaintiff's counsel can also read it to you. What you need to disregard, though, is any speculation on Misty Williamson's intent in writing that as to whether maybe she knew it was near the end. That part you should disregard.
The part I was referring to, you can read this. This earth is only temporary. It excites me knowing to think of going to heaven. God will keep me close.